United States Court of Appeals for the Fourth Circuit. Oh yay, oh yay, oh yay. All persons having the manner form of business for the Honorable United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention. For the court is now sitting. God save the United States and its honorable court.
Thank you. Good morning. Welcome to the Fourth Circuit. Please be seated. So we have a number of novelties here in this first case. This is the first one we've had where the judges are here, but the lawyers aren't. And I had the privilege last term to sit with Judge Motz. And she was her last time to preside. And now that she's moved on to different things, it's odd that she's not presiding and they're stuck with me. So with that, we'll move to our first case, 2020-52 Westfield Insurance Company versus Sisterfield Tank Works and some other folks. Mr. Kessler, which one are you? All right, we're here for you.
May it please the court, Your Honor. My name is Brent Kessler. I represent Westfield Insurance Company. The present appeal arises from a declaratory action initiated by Westfield in 2018, initially addressing 4 state court actions filed against Sisterfield Tank Works. One of those actions, the Sandy case, was voluntarily dismissed when it became clear that the claims arose prior to Sisterfield Tank Works beginning operations in 1984. The remaining 3 cases, which are at issue here on this appeal, are the Edwards, Price, and Steele cases. Each of those involved claims related to alleged exposure to benzene or other chemicals while the claimants were employed at various facilities in Marshall County, West Virginia, during years ranging from 1960 to as late as 2006.
Also, the panel is going to be familiar with the facts and the prior proceedings. So, in order to conserve your time, you might want to go directly to telling us why there's error here.
Your Honor, the district court erred to begin by electing to, or declining actually, to address the policies of insurance that were raised and noted in the declaratory action. Westfield's declaratory action addressed a CGL policy that was enforced from 1989 to 2010, and a separate claims made policy enforced from 1989 to 2001. The CGL policy expressly excludes product completed operations coverage, and Sisterfield Tank Works purchased that product completed operations coverage separately, either under the policy issued by Westfield from 1989 to 2001, or after that date from another carrier. Westfield raised those policies in its declaratory action because those were the only policies available to Westfield that it had access to. As early as 2010, Westfield had notified Sisterfield Tank Works in writing that it could not locate any Sisterfield Tank Works policies in place before 1989.
But what about, weren't there policies that were unveiled before 1989 during discovery? About
almost a year into discovery and the pending declaratory action, Sisterfield Tank Works undertook the investigation and search of its own records that Westfield had requested be done back as early as 2010, and located portions of a 1988 to 89 CGL policy and portions of a 1988 to 89 excess or umbrella policy.
But could the district court consider those policies to determine coverage?
Well, the court did that and actually found coverage under those policies. Sisterfield Tank Works had filed a motion and was granted leave to amend its counterclaim to address and raise for declaratory relief those other policies. They were not in the case up to that point. Westfield moved to dismiss
So
the
the district court, to follow Judge Nguyen, the district court considered those policies either under the claim sheet or parts of the policy. So why don't you tell us why the district court made an error there?
Well, in addressing those policies, and also relevant to the other policies the district court did not address, the district court predicted that the West Virginia Supreme Court would adopt a continuous trigger for coverage. In reaching that conclusion, the court relied on the cases that had been cited by Sister Girl Tank Works, which are distinguishable. Those two cases, the Wheeling-Pittsburgh case and the U.S. Silica case, were cases where in each instance, Wheeling-Pittsburgh, for example, dealt with a environmental contamination case, where the court specifically noted that the property was continuously and progressively damaged as soon as the contamination began. So there was evidence.
Let me understand. You seem to move away from the question of policies more now to the type of coverage that might exist, where there's a latent type situation here of whether it's continuous or manifestation as the theory to employ. District court, as you say, went with the continuous one. And so at this point, we are looking at West Virginia law, trying to discern how it would go. And the district court looked at two, trial court opinions from West Virginia. And so that's what you are now discussing. Is that right?
That's correct. In response to the question,
you don't think we should follow, or those opinions are informative on this, and going back to Judge Age's question, how did the district court error? Because both of those cases did use a continuous coverage theory, and even though one dealt with property, the other seemed to more deal with bodily injury. And I will also say, just in your answer, that even one that dealt with property cited cases that were supportive that dealt with bodily injury. So why is that not more informative than, I would say, even the district court case that came from the federal district court that was predicting? Why wouldn't we rely on those more so than than some other theory?
Well, because as I noted in the Wheeling-Pittsburgh case, there was evidence before the court in that case that there was damage from the start of the contamination. So there was evidence before the court of damage that would apply to result in a continuous trigger under each policy term. In U.S. Silica, the court relied heavily on Pennsylvania decisions that based their—
You're saying that even if a state has a manifestation theory, you can nonetheless have a case where evidence would permit an occurrence-based policy to kick in.
Correct, exactly, because in that instance, it's a continuous trigger because there's continuous manifestation. In U.S. Silica, the court noted specifically the scientific evidence that was before it, that there is injury that starts immediately upon exposure to silica dust. We don't have that evidence. In the district court,
at least one of your arguments was that you wanted us to certify this to the West Virginia Supreme Court of Appeals because there were conflicts between the state trial courts and the West Virginia district courts on which theory to use. Is that misread your brief, or is that an argument you're wanting us to consider?
It is an argument we want you to consider because we believe this is a critically important issue. We referred the district court to two federal decisions that predicted that the Supreme Court would apply the manifestation doctrine. And I believe those are the ones that carry the weight here. Because sir, this is an open—
Counsel, though, didn't you bring, you're the plaintiff here, right?
Yes.
And you initiated this case in federal court, right?
We did, yes.
So if you think state court is the place to have it discussed, why didn't you initiate it in state court?
The state actions were in multiple proceedings. In order to bring all the issues together into a single proceeding, it was most efficient to do that through a single declaratory action, which we filed in federal court.
But if we send it back to state court for resolution of this, have you lost this convenience that you had in bringing it in federal court?
No, we still brought all the underlying actions into a single proceeding for purposes of coverage, as opposed to having to intervene separately in what was initially 4 actions, ultimately became 3.
Why
So
couldn't
having
you
all the
excuse me, why couldn't you have done that in state court? I don't understand.
it would have been a more cumbersome proceeding, I believe, in state court, because in that situation, if we're going to file state court action, we would have needed to intervene, I think, in at least one and probably all of the state court actions. If we had only intervened in one, it's difficult to imagine how we could have pulled the other claimants from the other unattached state actions into that proceeding for purposes of the coverage.
Well, did you ask district court to certify this?
I believe we did address the possibility of that, but I'm not certain of that. I'm not certain of that. It is an open question. We believe that the law is sufficiently clear as addressed by West Virginia and as noted by this court. We referred the court to the Smith versus Animal Urgent Care decision, which noted specifically in a decision in 2000 that bodily injury, which is the defined term that triggers coverage under these policies, is based on the physical manifestation of harm. This court, the Fourth Circuit, in Ball versus Joy Technologies in 1991, concluded that mere exposure to chemicals was insufficient to establish bodily injury and stated the mere exposure of the plaintiffs to toxic chemicals does not provide the requisite physical injury to entitle the plaintiffs to recover for their emotional distress. And the court stated specifically that numerous courts have held that exposure to hazardous substances does not constitute a physical harm. That's the real issue here. The policies issued by Westfield, whether you consider from 1985 up to 1989 only or beyond, which is the ones we raised in the deck action from 1989 to 2001 for the claims or for the claims made policy, and 89 to 2010 for the CGL policy, all of those require bodily injury during the policy period of coverage for coverage to be triggered. That language is clear, it's unambiguous. Courts have found it to be unambiguous, and we've noted those cases. Here, the district court reached a different conclusion. It didn't disagree with our position on the 2000 policies, 89 to 2001, 89 to 2010 claims made in CGL policies, because the court chose not to get to them at all. But in adopting a continuous trigger, the court implicated coverage under every one of those, yet then decided that coverage under those policies that it had implicated by its ruling was moot because it found a duty to defend under the 85 to 89 policy. We believe that that is a clearly erroneous decision and that the court at a minimum should have ruled on the additional coverage issues. Sisterville Tank Works here.
So before your time runs out, I wanted to ask you about the other party here, the local insurance company and agent. I think they're referred to as Padden. And they filed a motion to dismiss because you've included them in the appeal. And I wanted to give you an opportunity to respond to that. Frankly, I have some difficulty seeing what your standing is as regards to them as a third party, how you're in any way injured by the grant of summary judgment to them.
We're not overly concerned about the agency defendants, and we did not proceed with any claim against them in the underlying matter. They were third-partied in. The problem was that in the judgment order that was entered, there were actually two judgment orders. If you
haven't made a claim against them, how can you appeal the grant of summary judgment to them?
Well, I believe you have the right to file an appeal when the judgment is entered and is based upon, as it states expressly, the finding of coverage against Westfield. That is in the judgment order. It didn't need to be, but it was in the judgment order that the district court entered, granting summary judgment to the agency defendants, as I refer to them, the Regal and Padden entities, and against Sisterville Tank Works. We did not want to be in a position where we appealed the coverage judgment order as between Sisterville Tank Works and Westfield, but yet there was this other judgment order that stated that coverage applied under the Westfield policies. If that judgment order is actually going to be a judgment that binds Westfield to a finding of coverage under these policies, Westfield certainly has standing in this case to have raised that on appeal, as we did with respect to Sisterville Tank Works. I see that my time is up.
Yeah, thank you very much. You've got some rebuttal time, Mr. Orth. We'll be glad to hear from you.
Thank you, Your Honor. May it please the court, I'm Ryan Orth, and I have the pleasure of representing Sistersville Tank Works, which is also commonly referred to as STW. And as Mr. Kessner indicated, STW was sued in these underlying actions. They manufacture these storage tanks in the chemical industry, and unfortunately, they became a venue-giving defendant in these underlying actions. And to jump into the main points here, the district court was correct in applying the continuous trigger and relying upon the West Virginia Circuit Court opinions adopting the continuous trigger and rejecting the case law relied upon by Westfield, including the state auto and the Ball case. And notably, the state auto and the Ball case are distinguishable on the basis that in state auto, the determination was made because manifestation actually ruled in favor of there being coverage under the manifestation trigger that comported with the reasonable expectations of the parties. And in Ball, the West Virginia Supreme Court of Appeals actually rejected Ball as an incorrect statement of law, and found that exposure without manifestation does constitute bodily injury. And while this was in the terms of medical monitoring, it is highly indicative of how the state Supreme Court would rule on this issue.
So cut to the chase. Judge Agee brought it up in terms of certification. Why wouldn't we certify this question to the West Virginia Court of Appeals? Well,
first, Westfield chose its form. They did not choose to put this in state court. And, the implications of certification to the state Supreme Court would, incur substantial expense, more delay for this action that was initiated in 2018. And the closeness of the question, given the distinguishing factors of the case law relied upon by Westfield, the two circuit court cases in West Virginia, and the Bauer case that rejected Ball, that was a state Supreme Court opinion in the medical monitoring context, does adopt the continuous trigger. So I think it's highly indicative of how the state Supreme Court would rule on this issue.
But you do see the conundrum wherein the state court is ruled in one way and the federal district court says manifestation. We're still in the predictive phase. I realize it's the delay and expense is there, but we've certainly done it in other cases, sometimes with even greater delay. And this is a very key issue. West Virginia has, as in other states, tremendous cases that come before them dealing with issues of this type. It's an issue that feels like it just needs to move beyond prediction to having something definitive from the court. And it seems to me that may well settle this matter.
Well, I think another key point here is that Westfield never raised this issue at the district court level. Their position has only changed now. The district court has ruled against them on this issue.
I think that's fair enough, and I'm not disputing that point. But we as a court, it's what we're looking at in terms of the overall system of justice. You're right. Everything points, as Judge Motz indicated, this ought to have been brought up in district court. I don't even know now if we bring it up. Is it possible for us to ask for certification and then send it back to the district court to answer that question in the first instance? That may well be something to deal with. But whatever it is could be fairly definitive on it. And it seems to me this ought to be settled.
And I take your point about your answer, blaming it on the other side. But if the district court had come out the other way, you would be up here telling us it should be certified. Wouldn't you?
Well, our position at the district court level was that the case law was indicative of how the state Supreme Court would rule on the issue. And another point is on
the question wasn't clear. I said if you had lost at the district court and you were on appeal here, you were appellant, wouldn't you be suggesting that the case be certified?
I presume that is a good point, but you know, of course, that is a hypothetical. And another point that I wanted to make.
It's a little bit more than a hypothetical. It's a pretty straightforward question. It may be difficult for you to answer, but it would seem clear that if you had lost, it would certainly be, as a representative person, you probably should ask for that point, thinking that West Virginia Supreme Court would go the other way in your favor. That's all that's going to. It's not trying to put you in a position of, you know, admitting one way or the other, but it may be hypothetical, but that's a realistic hypothetical situation. It's just a simple question of if you had lost, would you have gone there? And I don't think you're saying, yeah, I would have. I don't think you lose anything of saying it. You probably add a little candor to the conversation.
Yeah, yes, that is correct. And I think another point on this issue is that under the specifics to this case, the continuous trigger is more applicable because it comports with the expectations of the parties that there would be coverage for these types of claims, and the application of the manifestation trigger would convert the CGL policy into a claims made policy, which is not what the parties had contracted for.
So how do you get the expectations of the, I understand you're going to tell me your expectations, but what about the expectations of the other side? How do you,
well, I think
proceed from the record?
Well, I think because the parties also had the claims made policy from 89 to 2001, in addition to a CGL policy. I think that makes that distinction there.
I thought the court said it wasn't going to consider those policies.
That is correct, Your Honor, and that was our position, was that once the coverage determination was made under the pre-1980 policies, that STW was able to uncover after an exhaustive search during discovery that if coverage was found under those policies, there was no longer a live controversy under the 89 to 2010.
So you agree with the district court's ruling that it would be not right or moot, I think was the district court's term, to consider the 89 to later policies, but you want us to consider them though with respect to this other issue?
Well, Your Honor, I think that I was using that more as an example of the difference between the occurrence-based CGL policy and a claims-made policy, to the extent that application of the manifestation trigger here would convert STW's CGL policy to a claims-made policy.
So why don't you, opposing counsel says that the district court was wrong to consider the pre-89 policies and it should have considered the 89 and later years policies. So why don't you tell us why you disagree with opposing counsel?
Well, under the pre-89 policies, coverage was very clear once the continuous trigger was applied, because it did not contain the exclusions that Westfield relied upon in the later policies. Westfield has not argued that those policies are not indicative of that they do not provide coverage. They've only argued that the pre-89 policies aren't complete, or that the 88 to 89 renewal policies are not evidence of what the 85 to 88 original policies were. They haven't argued that coverage doesn't exist under those policies. Once that coverage determination was made, there was no longer any right of controversy as to the 89 to 2010. And all of that is based on mere hypotheticals that may never occur. It'll take a case where exposure is alleged outside of this 85 to 89 period and within the 89 to 2010 period for this issue to be right for a court to consider.
No, opposing counsel says we should, as I understand it, we shouldn't consider the pre-89 policies at all. So Can you speak directly to why you disagree with that?
Well, the policies were properly before the court to consider. To not consider those policies would have provided incomplete relief. And as far as the completeness of those policies go, Westfield was not able to point to any material terms that were missing, any material differences. I believe the only potential portions of the policy that may not have been able to be produced pertain to automobile coverage, and then just common policy declarations that have nothing to do with the issue of coverage under those policies, especially with regard to these latent disease cases. And under those policies, STW was able to prove all of the material terms and conditions. The district court correctly found that there were no applicable exclusions under the pre-1989 policies. And they correctly found that coverage was triggered when applying the continuous trigger under those policies. And there, the controversy, the relief sought by Westfield and the declaratory judgment action was whether there was a duty of coverage to STW for the underlying matters. Once coverage was found under the pre-89 policies, that was accomplished. And Westfield has devoted some time in their brief to the merits of the post-89 coverage. And given that the district court did not address those issues, that's really not at issue in this appeal. Once the district court found that those issues were moot and would amount to nothing more than an advisory opinion. Additionally, Westfield has, in terms of arguing the continuous versus the manifestation trigger, Westfield's issues with the Wheeling Pit case in U.S. Silica go to the issue of whether the bodily injury was simultaneous to the exposure. And that goes into the merits of the underlying applications, or the underlying allegations, whereas for a coverage determination, it only matters that the allegations in the underlying actions are reasonably susceptible to an interpretation. And given that each of the underlying plaintiffs have alleged that the exposure occurred causing the bodily injury, they are reasonably susceptible to that. And the veracity of whether that is true or not, whether STW did anything negligent, STW would agree with Westfield that STW did not commit any negligent act. However, the claims of the underlying allegations bring that into play. And, under the 8 corners rule, there is no consideration of the underlying facts. If there are no further questions, I believe that concludes my argument.
What about the appeal as to Regal and Padden? What's your position on that?
The district court's ruling was contingent. By finding that coverage existed under the Westfield policies, that meant that there could not have been negligent procurement on behalf of the agency. And so by making that finding, it made STW's allegations against Regal and Padden that they weren't right because there was a finding of coverage. The claims were based, the claims initially were based that if there was not proper coverage, that fell on Regal and Padden. Given that if this were to be remanded and a decision was to be overturned, then claims against Regal and Padden could then become ripe.
So do you agree or disagree that we should grant the motion to dismiss the appeal as to Regal and Padden?
Well, I think it all, I guess the fact that they are involved in the appeal, they really don't have any arguments in the appeal. that it's merely contingent based upon the way that the district court ruled, and that from STW's perspective is that as long as it would not impact STW's claims against Regal and Patton in the event that this decision was overturned, STW has no objection to Regal and Patton being dismissed from the appeal.
Right. Thank you, Mr. Orth. Mr. Lumsford, you have a minute.
Thank you. May it please the court, I am David Lunsford and I represent the defendants appellees, Mr. Edwards, Mrs. Price, and Mr. and Mrs. Steele, who have brought separate tort actions against Sistersville Tank Works as a result of their or their spouse's development of certain cancers. As the court saw in the briefings, my clients took no position on the merits of this declaratory action when it was pending before the district court, and likewise took no position on the merits of this appeal in the response brief filed with their co-defendant, Sistersville Tank Works. As such, my clients are taking no position on the merits of this appeal today.
All right, Mr. Pierce, you have 2 minutes.
May it please the court. Good morning, Your Honors. My name is Zach Pyers, and I represent Regal and Patton and David C. Patton on this appeal. The court's already hinted at and asked specifically both Westfield and Sistersville Tank Works their position on the motion to dismiss. And really, the only reason I'm here to argue this morning before you is to reiterate our position on the motion to dismiss, that both the Patton defendants are not proper parties to appeal. The only party that brought claims against the Patton defendants was Sistersville Tank Works. Westfield did not assert any direct claims, and they've stated as such here. When the motion for summary judgment was granted in favor of the Patton defendants, there was not only was one of the basis that Sistersville Tank Works was afforded coverage under the Westfield policies, but there is also the fact that Travelers Insurance was also providing Sistersville Tank Works a defense in the underlying action, which was not related to the decision as it relates to Westfield's coverage. And so the reality was the district court's decision determined that there were no damages that Sistersville Tank Works could prove in the underlying action. The other issue is that Sistersville Tank Works also argued before the district court, even if it was found under the Westfield policy, that they still had sustained damages. The court rejected that argument. That was not contingent upon the coverage. And so the Sistersville Tank Works defendants essentially sought to afford other theories of liability separate and apart from the coverage, and the court rejected those arguments.
But if we should reverse, wouldn't that have an effect on you?
I'm sorry, Your Honor.
If we should reverse the district court, wouldn't that have an effect on you? Why would we grant your motion to get out of the case now? I would think that would be to your disadvantage.
Well, Your Honor, I don't believe we should have been a party at all, which is why we filed the motion when we did at the beginning of the appeal. And we don't believe that any decision, because there is no appeal as it relates directly to the decision, since Westfield has no standing to assert the claim and Sistersville Tank Works did not file an appeal against us, we believe that the decision and order, which separately indicates, and I would refer you to the actual order from the court, it ordered the clerk to enter a judgment separately in favor of Sistersville Tank Works and in favor of Regal and Patton. And based upon that order from the court, we believe that the separate order that was supposed to be put in place by Regal and Patton stands as long as there is no direct appeal to that order by Sistersville Tank Works, which there has not been.
All right, thank you very much, counsel.
Thank you, Your Honors.
Kestner, you have some rebuttal time.
Thank you. I want to speak just briefly on to the issue of the possibility of certifying the question. The court's comments make clear this is an important issue. And I think it's a significant note when the court said, haven't we reached the point where we should move beyond prediction? Obviously, yes. I don't believe there's a waiver of a request or a suggestion that the court might want to consider certifying this issue merely because that wasn't presented squarely before the district court. I'll refer the court to the case of Columbia Casualty versus Westfield Insurance Company, which was a coverage case that went to the fourth circuit.
There's no waiver.
Yeah. So I believe that the court can consider doing that if it elects to do so. It's of course your discretion. Counsel for STW has argued that to adopt a manifestation trigger is essentially a conversion of CGL policies into claims made policies. That is simply not accurate. If we go back and we look at the Wheeling-Pittsburgh case and we look at the U.S. Silica case, in both of those cases, the court found that there was injury and damage that occurred upon the environmental contamination of the property instantly when that started and continuously, or to exposure to silica instantly when that happened and continuously. There's no requirement that when that injury or damage occurs, that a claim for that be made within the policy period. It is only required that the injury occur during the bodily period. That's what the policy says. Counsel has attempted to distinguish and say that the Ball versus Joy Technology case has been repudiated by the West Virginia Supreme Court in Bauer, but that is simply not true. The Bauer case doesn't adopt a continuous trigger. The Bauer case simply approved of actions for medical monitoring. But in doing that, in the exposure context, the court was specific in noting that what it was addressing was an economic harm, not a physical harm. Economic harm under West Virginia law is not does not fall within the definition of bodily injury. Our Supreme Court, in the case of Alois versus Nationwide, addressed that specifically, noting that economic harm does not represent bodily injury under these types of policies. That case dealt with a homeowner's policy, but the policy language and the circumstances are the same here under a CGL or an umbrella or excess policy.
Can I ask you a question about the 1989, I think it's 89 to 2010 policy? You seem to, you aren't making a claim with respect to that? I'm just not very clear. I would think that you would want cumulative coverage.
I'm not sure I understand the court's question. The court's continuous trigger approach implicates all those policies, but we believe under the 89 to 2010 CGL policy, coverage is clearly excluded. Each of those policies absolutely expressly excludes coverage for product completed operations exposure. Each of those policies also requires bodily injury to have occurred and existed for property damage during the policy term. So we have that same issue of manifestation of the physical harm or damage during the policy term, which is not present here. It's clear, and SDW hasn't even presented the court with any colorful arguments, that coverage under either that CGL policy from 1989 to 2010 or the separate product completed operations claims made policy from 89 to 2001, those policies simply provide no coverage for these claims. Counsel mistakenly said, however, that we don't dispute that coverage would apply under the 85 to 89 policies. Again, we raised the issue that the court below, the district court, didn't have complete policies. But regardless, those policies would not apply to provide coverage here for the same issue and for the same reason that we've addressed on the CGL policy from 89 to 2010. And that is, those policies expressly require bodily injury during the policy period. So we get to this same continuous trigger manifestation, but really the underlying issue is, when does the bodily injury occur? You can have 10,000 people work in an environment or walk through an environment where there is allegedly benzene fumes. And has every one of those people suffered a bodily injury? And the answer to that is absolutely clearly no. So if the law does not.
It's before you get off, from a textualist perspective, if you look at that policy, it has language. The policy applies to bodily injury, which occurs during the policy period. It says occurs, not manifests. If we follow that approach, how does that support you?
And that's the argument that I'm making. for the bodily injury to occur, it has to be present in some way that can be identified, that can be measured, that can be observed, that can be detected. Otherwise, it has not occurred. As this court noted, again, in the Ball versus Joy Technologies case, mere exposure does not constitute bodily injury.
But it says occurs, not manifests.
I agree, but manifest is perhaps a misleading term in the sense of, in my mind, it means visualized. But I think the broader definition of it, as noted in the two cases from state court that the district court relied on, it's sufficient if the injury or harm is detectable, measurable, confirmationable, as opposed to undetectable.
Thank you.
All right, thank you, counsel. We appreciate the arguments from all the attorneys in this case. As you know, our custom in the Fourth Circuit is to come down in the well of court and greet counsel after argument. We're still COVID restricted in that regard, so we'll wish you the best virtually and hope that you can return in the future when we're able to resume our normal and customary practice. So with that, we'll be at ease here momentarily while counsel for the second case comes up to their respective desks. And our notes indicate that we have some students here from the University of Virginia Law School, which is the alma mater for Judge Motz and myself. And we're glad to have you here today and hope you'll find this interesting. Oh, I neglected to say, Judge. So whenever council's ready, are we missing a set here, Mr. Coleman?
They're remote.
Oh, I see they're remote. Now we have a lot of lawyers up here on the television screen. Are we ready?
Yes, sir.
All right, our next case is the United States versus Bethia. Mr. McClellan.
Thank you, Judge Agee. May it please the court, Sean McClellan on behalf of appellant Rayco Bethia. The central question in this case is whether Mr. Bethia can continue to qualify for consideration for compassionate release, even after getting the vaccines.
Even after what?
Even after getting the vaccines, Your Honor, for COVID-19. Mr. Bethia has a number of conditions that put him at dramatically elevated risk of COVID-19.
Is your the brief that pitches this that the only reason that the district court denied it was that he had got the vaccine, had the vaccine?
That's correct, Your Honor.
I don't think that's reflected in the record.
Analytically, Your Honor, vaccination was the dispositive point that disqualified Mr. Bethia from compassionate.
If we disagree with you, then you lose. Is that what you're saying to me?
No, Your Honor.
Branch out to other arguments.
Well, Your Honor,
make that argument if you want to, but I would also make other arguments.
Certainly, Your Honor. I'll touch on the 2 points that the government identifies as other.
To be clear where Judge Motz is going, if you read that district court's answer, it's clear that's not all that the district court relied upon.
Well, yes, Your Honor.
It's rather unfair. We don't need to read the language to you, but sometimes it's, I mean, we're the court, we like to hear argument, but why have you go this is if it's clear what we're seeing, unless you can tell us it's not clear, but it's right there.
Well, yes, Your Honor. There's
a move to another point. I think what she's making.
Understood, Your Honor. I think there's essentially 3 COVID-19 related considerations that the district court identified. Of the 3, vaccination is the only one that could have flipped Mr. Bethia from qualified to disqualified for compassionate release. As a baseline, he faces an extraordinarily elevated risk of COVID-19. He's a 47-year-old racial minority in one of the highest COVID risk facilities in the BOP system. He also has a number of medical conditions. He has stage renal failure that requires him to get dialysis 3 times a week.
Actually contracted COVID-19 since this ruling.
Your Honor, it's not on the record. He has tested a number of times and has not tested positive, Your Honor, as far as I'm aware from the record, and including the last year and a half, I'm quite confident he's not, Your Honor. But he does continue to face an elevated risk as the CDC recognizes. The district court
Well, didn't the
identified.
district court recognize that several times? I mean, that goes into quite a bit of detail about, I'm aware of his medical problems. He describes his history of lupus and kidney problems, blood pressure, 14% kidney function, stage 5 renal failure. Has related conditions that spin off from his kidney problems. And then it identifies what's happened in the penitentiary on how the Bureau of Prisons has addressed those.
That's correct, Judge Agee. The district court recognized that Mr. Bethea's conditions would put him at elevated risk of COVID-19. And that would undoubtedly qualify Mr. Bethea as a baseline for consideration for compassionate release. That's well established in cases like High, Hargrove, Petway. So the district court identified 3 points that could have possibly flipped Mr. Bethea from qualified to disqualified. First is the vaccine point, and we think that read fairly against the backdrop in the law in this area, that was dispositive. But the other 2 points that the government identified.
So tell us where you or Mr. Bethea ever made that argument to the district court.
Yes, Your Honor. So Mr. Bethea raised a JA 150 to 151 and JA 204 to 209 his elevated COVID-19 risk.
Now, I'm talking about vaccine. Where did you tell the district court specifically that because of the vaccine that was inadequate as a matter of law for Mr. Bethea's situation?
Yes, Your Honor. At JA 283, Mr. Bethea's appointed counsel, which he had been appointed just minutes earlier, indicated that Mr. Bethea's ongoing elevated risk existed notwithstanding vaccination status, Your Honor.
I don't think there's any question that the district court recognized that at multiple places. So you've got to tell us where, in recognition of that, why the district court's explanation at some length was inadequate, and inadequate as of that date, not as of today.
Well, that's correct. Yes, Your Honor. And we do focus on March 2021, although the last year and a half has confirmed an elevated risk, notwithstanding vaccination status. The district court essentially, getting back to the 3 points that the district court identified, first was vaccination. Second was the BOP's general mitigation efforts. And then third is that Mr. Bethea was isolated after he was exposed one time. Those second and third considerations would be insufficient to disqualify Mr. Bethea on their own, essentially because they didn't either address the particular risk that Mr. Bethea faced.
What if we give you that the district court erred on this extraordinary and compelling reason analysis? We still could affirm this on the fact that the district court used those 3553A factors there, considering the hearing transcript. When we look at his whole abuse of discretion standard, can we fairly say that the district court abused its discretion? I mean, look at it. By my count, it looks like he considered at least 8 of those factors there. Why is that not enough to assure that it has a reasoned basis for its decision?
Well, Your Honor, the 3553A analysis, the district court here is a poor alternative basis for affirmance for a couple of different reasons.
It can be. The question is, you can establish the first extraordinary compelling reason analysis, but we still could affirm it on that. And you characterize it being poor, but he considered at least 8 of those factors in there.
Well, the key one that it didn't meaningfully consider, Your Honor, is rehabilitation. And as this court's cases, most prominently Martin, make clear, a detailed individualized explanation of rehabilitative efforts like Mr. Bethea has engaged in here, a nearly spotless, entirely nonviolent 7-year disciplinary record.
Actually, I remember the district courts. I remember what he said. He's only had 2 violations and I regard those as minor.
That's correct.
So I know he did consider it.
Well, it's not the sort of individualized explanation that Martin imagines, Your Honor.
I thought it was pretty individualized if he knew the record well enough to know that they were minor. And to me, that counted in your client's favor.
Well, yes, Your Honor. Martin directs, I think it's fair to say, a much more thorough analysis of why those efforts are meaningless, especially if a defendant is serving a life sentence, as Mr. Bethea has here.
He did not conclude that they were meaningless. The district court, it seems to me, did think they were meaningful. He just put it along with all the other factors.
Well, yes, Your Honor. We would argue that the Martin consideration needs to be more thorough and find support for that proposition in Petway, where the district court had also commended a defendant for rehabilitative efforts, but this court nonetheless vacated and remanded for a more thorough qualification analysis. And we think those rehabilitative steps are quite significant on this front, Your Honor, because as Martin, one of the key lessons of Martin instructs.
It's significant was district court to consider rehabilitation, call it commendable. Do you think more needs to be done?
Under Martin, yes, Your Honor. More needs to be done, a more individualized assessment. At bottom, the district court's discussion of this point is essentially 2 paragraphs of transcript discussion. Martin suggests a more detailed walking through these steps. Mr. Bethea had been at that point in prison for 5.5 years, Your Honor. He maintained an exemplary disciplinary record. Those are meaningful considerations.
For a reasoned basis for this decision, and he's considered at least 8 of those factors.
That's true, Your Honor, but
you pointed out on rehabilitation, for which he says is considered or whatever, and says is commendable. And you're saying even consideration of all those other factors and then saying that the rehabilitation commendable, he needs to do more?
Yes, Your Honor. The key lesson of Martin is that the rehabilitation consideration, especially after so many years of incarceration, can meaningfully recast those other factors. So yes, it's true the district court addressed a number of other factors during the original resentencing that preceded the compassionate release hearing. But if the district court had meaningfully grappled with Mr. Bethea's rehabilitative efforts, those factors could well have been recast.
So the district court, I want to be sure we have a lot of these cases, and I want to be sure I have the right one. The district court seemed again and again very concerned that your client had been selling drugs from his house when he was awaiting trial.
That's correct, Your Honor. The district court repeated a number of times its concern about Mr. Bethea's pretrial release violation.
I did do that. And that's not an unfair thing to talk about, but your position is that district court overly emphasized that, I guess.
That's correct, Your Honor. The district court overly emphasized that, and it amounts essentially to a recitation of the original criminal behavior.
Well, can I ask you a question? Is your argument rooted in the fact that your client has very serious medical conditions, and that in and of itself gets him out of prison now?
No, Your Honor. Mr. Bethea's very serious underlying medical conditions qualifies him at the first step of the compassionate release inquiry.
Okay.
Qualifies him for consideration.
Okay. And what other things does he have going for him on this?
On the qualification front, Your Honor, on the 3553A analysis?
Well, why should he be getting out of jail except for in addition to his serious medical conditions?
Well, Your Honor, we would return to the considerable rehabilitation efforts, his increased likelihood of getting a kidney transplant upon release, and his ongoing family support, all of which was either given extraordinarily short shrift by the district court or ignored entirely. Specifically, the kidney transplant issue, the district court did not address. The district court was aware that he needed a kidney, but did not address that he would have an increased likelihood of getting one if he was released. And the district court really didn't consider that. Is he currently
still in line for a kidney transplant?
My understanding is he is, Your Honor.
Has not received one.
But has not received one. It's extremely difficult to get a kidney transplant in Bureau of Prisons custody, as various courts have recognized, but the Central District of Illinois discusses it in Salcedo.
Is he taken off the list by virtue of being in prison?
I'm not sure the exact mechanics, Your Honor, but it becomes increasingly hard to get a kidney transplant of any variety in Bureau of Prisons custody.
Are his symptoms in remission?
No, Your Honor. He receives dialysis 3 times a week, which maintains.
What about his other problems?
His other problems he's receiving medical interventions for, but I wouldn't describe him as being in remission, Your Honor.
So as you're going back to your predicate, before we get to the 3553A part of it, am I understanding correctly your response to Judge Mott's that because of the conditions he has, that in and of itself qualifies as a compelling reason as a matter of law, regardless of what the Bureau of Prisons does to treat or ameliorate those conditions?
Judge Agee, I would say it makes it extraordinarily likely for Mr. Bethea to qualify at the first step of the
Yeah,
analysis.
but that isn't answering the question. We understand. Is it a get out of jail card?
It's not a get out of jail card, Judge Motz and Judge Agee. At bottom, the key inquiry on this first step qualification for consideration question relies on a particularized assessment of a defendant's risk level. So it's possible to imagine a situation where Bureau of Prison mitigation efforts directed at Mr. Bethea specifically.
You're talking now about medical risk, not criminal activity risk.
That's correct, Your Honor, talking about medical risk of COVID-19. And this court's
But let's assume that you are correct with respect to medical risk. I thought that was the gist of my colleague's question to you. Assuming you're correct there, does that get you out of jail free?
No, Your Honor, the district court still needs to conduct a second step 3553A analysis.
Which it did here.
Which it did, but is faulty because it didn't address the rehabilitation point as Martin directs. And so as a consequence, the 3553A analysis is insufficient alternative basis for affirmance.
When you're talking this in terms of how these things are done, and I've seen other cases in which sometimes an individual gets so sick, you actually allow him to go out and get treatment outside. And I'm thinking in terms of the medical treatment he's getting there, the COVID-19 is a consideration, but you indicated he's not gotten that. He's on dialysis and getting medical treatment continuously in prison. I take it that by releasing him, you think he's going to get better treatment on the outside, or there's some advantage there?
Well, Your Honor, the key benefit of early release for Mr. Bethea in this setting is that he could socially distance to avoid COVID risk. That's not something that's really easily available in BOP custody, and is specifically not particularly easy at NCFP Springfield, where he's currently incarcerated.
But is it a factor that he made this ruling was made in March 2021? He's not gotten COVID yet. I mean, why is that something? All the things that are there, he's fully vaccinated, everything there, he's in prison. And it would seem some point in time, it's been over a year and a half or so now. He hasn't gotten COVID. He's getting full medical treatment, dialysis twice a week. He's in a setting where he's being monitored, given his behavior outside, whether that's to be considered or not. Apparently, if this is the case, I'm thinking about this. This is someone who had a deal. He didn't have to go to prison at all. Is that, am I talking about the right case?
I see that I'm out of time, Your Honor, but if I could just answer your question.
Go ahead.
Thank you.
He had a deal, didn't he? That he didn't have to go to prison at all.
There was no.
What the situation was, whether it was drug addiction or whatever, he just couldn't do it.
Well, Your Honor, he was certainly going to prison the entire time. There was a pretrial release violation, but for the reasons that we've discussed.
Plea, wasn't there a plea or something? Or do I have the right case? I mean, a lot of cases are just not, but
that's correct. Well, that required him to.
Well, he was going to avoid life in prison, wasn't he?
Well, he was still going to be incarcerated for a lengthy period of time, Your Honor. And the COVID risk point, I mean, the fact that he had been exposed one time suggests that the BOP's mitigation efforts were not sufficient to limit his risk. That I'll save the remainder of my time for rebuttal.
All right. Thank you very much, Mr. DeHall.
Thank you, Your Honors. May it please the court. I'm Andrew DeHall, and I represent the United States. As the moving party, Mr. Bethea had the burden of persuading the district court that he was entitled to compassionate release from the sentence it had just imposed. He failed to meet that burden. He failed to demonstrate that he, in particular, had extraordinary.
Mr. DeHall, according to the clock we have, he's gotten an extra minute plus already,
Yeah,
which you may not need.
so we're starting you over.
All right, go for it.
Thank you, Your Honor. As I was saying, he failed to meet his burden. He did not show that he, in particular, had extraordinary and compelling circumstances making him eligible for release. And he did not.
The other side on that point, it seems to be that the district court essentially did it on a per se kind of basis, with the vaccination. And we sort of addressed that at the beginning, but any further comments on it?
I don't want to put words in the court's mouth, but I believe the reading of the transcript, that it was a full consideration of the evidence presented to it is correct and is consistent with what this court later said in Hargrove, which is that's the totality of the circumstances analysis based on the evidence that's presented to the district court.
So looking at the totality of the circumstances here, why does his conduct warrant more serious punishment than the majority of his co-conspirators?
Well, one thing that the district court pointed out in the sentencing phase was there was a discussion about acceptance of responsibility. And what the district court noted here, this wasn't a garden variety act that caused Mr. Bethea to lose acceptance. It was.
I understand. It was this business about selling out of his own house.
Correct. It was, being on release, awaiting sentencing, and really returning to the conduct that had gotten him indicted in the first place. So that distinguished it. That is something that came up.
Why is that conduct, which is bad and silly, why does that conduct outweigh his behavior since, which the district court recognized was a good record?
The district court was concerned about further return to that kind of conduct, as was brought up in the other argument. There was a plea deal here that was going to allow Mr. Bethea to avoid what was then a life sentence and try and get back on the kidney transplant list. He was actually on the transplant list and was about to get one and was arrested for the underlying conduct. So he was allowed to have those things. And despite those really incredible once in a lifetime incentives, returned to bringing drug dealers into his home to cook crack cocaine. That gave the district court a lot of pause that if those incentives weren't enough to deter him, then an early release would not be a deterrent from further activity on that front.
And I really do understand the district court's chagrin and justifiable horror in what he did. But what I'm looking for is a balance here, because that's what the district court is about. And for example, does the brief mention of mitigating conduct meet the standard that we set forth in McDonald? And it is very brief here.
I think it does. So first, I think the takeaway from McDonald and from Martin is to have something in the record indicating that the court did listen and considered the rehabilitative efforts in prison. And here I would note that it wasn't even that the judge considered it. He was actually the one who brought it up. I think it's at page, oh goodness, I think it's 259 of the JA. He says, well, we've got this case where Judge Gregory is talking about the amount of mitigating evidence. What do you have to say about that? And he pressed the AUSA on that matter. And as your honors pointed out, that he did go on to say, I think it was commendable. He got a relatively minor record. But and then at the conclusion of his argument, he says, or not argument, his explanation, he says, I just can't get around this breach of trust on pre-sentencing release. So I think that shows consideration, and certainly not just an oversight or refusal to consider that evidence. But then the I just can't get around language signals a weighing.
The question really goes to question of why did the district court explain why this mitigation evidence was insufficient, dealing with the case of Martin and McDonald. And when you think about the behavior, the 2015 behavior, it seems like it double counted because he always did that. The question is it possible to overcome that with sufficient rehabilitation evidence? And he had a virtually flawless record since being incarcerated, including when he thought he was in on a life sentence. So that's really kind of the troubling factor dealing. As I understand, we're dealing with the first prong here. The prong that deals with extraordinary compelling reasons analysis. So, but you know, when we go to that extent, that seems to be problematic as to why it never explained why that mitigation evidence was insufficient.
Well, I think in that colloquy with the AUSA, when he presses him to say, why wasn't that enough? The ultimate conclusion was, well, it hasn't been as long. It hasn't been as long as McDonald or Martin. And there has been some effort to get relief from the sentence through appeals. And so the district judge indicated, I think, I don't want to misquote him, but I believe he said, well, okay, maybe that carries a little less weight. So
I'm sorry, I didn't understand your answer.
And it wasn't a very good one. I apologize.
No, it's me.
So my understanding in reading this record is when they discuss Martin and the rehabilitation efforts on, I think, JA 258 through 260, the judge ultimately says, okay, well, I see that maybe this evidence of coursework and discipline is commendable, but maybe it's not quite as compelling as what was there in Martin and McDonald. And on top of that, you know, he hasn't been in prison quite as long as some of those people. So maybe it does carry a little less weight to me.
Is that the appropriate analysis?
I think it's a permissible analysis to say that maybe the facts of those two cases are distinguishable, and so it doesn't carry as much weight on that. It certainly is just I mean, I don't think there's any disagreement that the judge was still taking that into consideration. He never said, well, I'm just going to disregard that, and I don't care about that. It was a balancing of several different considerations. It just happened to not be the one that prevailed.
I guess that I'm so struck by the fact that the district court, that all roads lead to him selling the drugs outside of his house or from his house before he was ever sentenced. And that is, you know, stupid and bad and everything else. But if you're never, ever going to, if that locks you in prison forever, I don't know.
Well, I understand the concern. And again, I think it wasn't just, well, you were charged with selling drugs out of your home. It was, you went back to this despite having such a great chance to avoid a harsh sentence. You did it in a home that, well, your family was not there, but you shared with them. It was, and you did it despite having a chance to get a kidney transplant. I think that was what really bothered the court, was not simply that it was selling the drugs. It was, wow, like what more could you have gotten out of this? And if that wasn't enough, then maybe letting you out early isn't going to solve it either.
One part of his plan for release here on compassionate release was he was going back to the same home, the same environment where this happened before.
So I believe at one point he talks about maybe living with his mother or his mother-in-law. He does talk, you know, in his letter to the court that he read during the hearing, that he wanted to go back and live with his family. So that would be, you know, that would be an issue of itself. I can't say that the district court specifically talked about the potential for living with his mother-in-law. But I think if you look at the record where I think it's a JA 291 through 292, you know, I just can't get around that he was doing this in a home that he shared with his wife and kids. So I think that signals some concern about him, of Mr. Bethea, going back to his wife and kids, because it wasn't a sufficient deterrent last time.
Well, what about I don't know, it may have been a discussion between the court and the government. Well, it seems like I remember there was some discussion about part of the rehabilitative effort would be to get a job. He was going to go to work at UPS, and the point was made that, well, he was on Social Security disability. How's he going to do that and work for UPS at the same time?
Right.
Am I remembering the right case, or have I got this mixed up?
You are, Your Honor, and I have to admit, I don't have a JA site for that one, but that was something that the government brought up in response, was that it does seem inconsistent to say that he's going to get disability if he has a job lined up. So, was there an overt credibility finding on that? There wasn't, but that was an inconsistency that was explored in it. That seemed to give the district court some pause.
So if perchance Mr. Bethea didn't succeed on this particular compassionate release, is there any barrier to him filing another one tomorrow?
No, Your Honor. Now, while this appeal is pending, the district court couldn't rule on it, but as this court said in Holt, there's no bar on successive compassionate release motions. And so if there's new evidence that Mr. Bethea wants the BOP and then the district court to consider on his medical needs, the circumstances of COVID, how it might affect him, and further rehabilitative efforts, family circumstances, anything like that, he may do that. He's not stuck if this court affirms.
Anything else you want to tell us about?
Your Honor, if there are no further questions from the court, we would respectfully ask that the district court affirm.
The judge
I
went
just
this
had
question.
one question.
Yes.
Be sure we discussed the rehabilitation, and this is a two-pronged analysis, and that goes, in my opinion, it looks like it goes to extraordinary compelling reason analysis. There's still the 3553 factors. It's a separate basis upon which we could affirm the district court. Are they separate in terms of the thought process, particularly as we discuss the consideration of mitigating rehabilitative factors, if those factors outweigh, at least in the judge's opinion, discretion of the rehabilitation?
I think, Judge Wynn, I think that the same facts and considerations can play into both. I was actually thinking about that this morning do you have to separate those into two steps? And, I think it was the Harris case where this court actually vacated because the district court did not consider rehabilitation in the first step, said, no, you don't get to consider that until the second. And really, as a practical matter, a lot of the same facts are going to be relevant to both considerations. For example, if someone's terminally ill with cancer, that probably is going to give them extraordinary compelling circumstances. If they're so ill with it that they're bedridden, they probably have a low risk of recidivism on that too. So I do think that the same considerations can factor into both. And I think that was done here.
Okay.
All right. Thank you very much, Mr. DeHall. Mr. McClellan, you've got some rebuttal time.
Thank you very much, Judge Agee. I'll address one of the last questions by Judge Wynn first. Typically, I think this court views rehabilitative efforts actually in the second prong 3553A analysis. That's what it did in cases like Martin, for instance. So considering the rehabilitative efforts in that second prong 3553A analysis really puts into context the other sentencing factors. As we've discussed, the rehabilitation analysis the district court did here was pretty short shrift. And I think it's worth actually diving a little bit into how the district court seemed to distinguish cases like Martin and McDonald. The district court discussed those cases as opposing counsel mentioned, JA 258 through 260. And its ultimate conclusion on why Martin and McDonald were basically irrelevant here appears on JA 260. District court says that there's new law coming down on sentencing. So essentially, Mr. Bethea's rehabilitative efforts are less significant, can be disregarded just because there's a new act out there, even though he had been serving 5.5 years up to that point on a life sentence. The government also raises in its response brief on appeal an additional basis for distinguishing Martin and McDonald, the fact that Mr. Bethea had fought for years to challenge his original sentence. I think that's also inconsistent with Martin for pretty straightforward reasons. Namely, Ms. Martin also challenged her sentence repeatedly prior to receiving relief from this court. One additional point on the successive petition issue. Certainly, Mr. Bethea does not have a bar on filing a successive motion. In this case, he could file another motion for compassionate release. But this court has long recognized that these issues are appealable, and as a consequence, should be analyzed in the context of the original district court decision on the subject. The district court's decision here was erroneous. It erred on the qualification front by failing to conduct a particularized inquiry into Mr. Bethea's ongoing COVID risk, notwithstanding his vaccination. And then the 3553A analysis is sufficiently deficient to not constitute an alternative basis for affirmance here. The court has no further questions. I'll return the balance of my time.
All right, thank you very much, Mr. McClellan.
Can I ask you just, I'm sorry.
Yeah, go ahead.
Certainly.
So when the district court was going through and looking at this case, he talked about prior convictions. And then he said, but he spent little time incarcerated. Is that an appropriate thing to look at?
I don't think so, Your Honor.
Why not?
The limited number of times that the limited period of time he'd been incarcerated, Your Honor?
Yes, he had many convictions, but he hadn't gone to jail, is what the district court is saying, or hadn't gone to jail for very long. Is that an appropriate thing to look at?
Well, beyond factoring into the guidelines calculation, it's not obvious to me that it is. We haven't briefed the issue in great depth. We're happy to provide supplemental briefing on the issue if that would be helpful.
You can see that I think this is a pretty close case, and we're scratching around to find what's there. And I think we're not satisfied with just saying that the district court, the argument that you put forth in your brief, that doesn't seem satisfactory to us. And so you have nothing to tell me about that. Okay.
Well, Your Honor, to the extent it's a head scratching close case, it's certainly one that would benefit from additional explanation by the district court. A lot of its explanation is quite brief, as Your Honor identified with respect to the rehabilitation.
This is a little out of the ordinary because you have one hearing, the bulk of which goes to a resentencing, which your client got, and the compassionate release, but it was all done in one proceeding. And so you've got all this information in there, some of which may be relevant for the resentencing, some for the compassionate release, and some for both of it. So it's not like the ordinary compassionate release hearing where it's just an isolated consideration.
That's correct, Judge Agee. It is an unusual posture, but even if one considers the resentencing discussion, the lack of meaningful in-depth analysis of the rehabilitation nonetheless dooms the compassionate release 3553A analysis. For those reasons, we would respectfully request that this court vacate the matter and remand with instructions to consider Mr. Bethea's ongoing COVID-19 risk, as well as to consider the 3553A factors, including rehabilitation.
So you're court appointed?
Yes, Your Honor.
Well, that's fine. And when you leave today, you're going to leave Mr. Bethea behind, is that right?
No, Your Honor. Would be willing to assist him in whatever additional capacity. If the court is interested in appointing counsel for further district court proceedings, would be open to that as well, Your Honor.
Okay, thank you.
Well, I do want to note that you are court appointed and how much the court appreciates your agreeing to assist the court and the administration of justice, which we could not do unless there were individuals like you who are willing to undertake this. And I want to compliment all counsel on an excellent job they did today and say again that ordinarily we'd be coming down to shake hands, at least with you all, but we're not in that practice at this time. So with that, I'd ask the clerk to declare us in recess very briefly, and then we'll come back and take up our third case.
This honorable court will take a brief recess.
All right, please be seated. And we'll take up our next case, Wild, Virginia versus the Council on Environmental Quality. Ms. Hunter.
Thank you, Your Honor. Good morning, Your Honors. May it please the court. I'm Kim Hunter with the Southern Environmental Law Center, and I have Nick Torrey and Megan Kimball with me here at council table. And we represent the 17 conservation groups who are plaintiffs in this case. Your Honors, the National Environmental Policy Act provides.
The first question you're going to get from this is you've had this policy and now the Biden administration is working through it. You got a lot of other cases similar to this. How in the world would we just hold this thing? Let's see how it's going to pan out for you. It looks like to me it's going in your direction.
Well, certainly, Your Honor, 2 years ago when we were arguing this case before the district court, a little less than 2 years ago, that might have been the case. And at that time, the Biden administration.
The case that you would hold in abeyance, or
that things look like they would be heading in the direction that our plaintiff groups would like them to, and that we would have.
When did you argue before the district court?
I'm sorry, Your Honor.
When? Oh, the date?
We argued in, I think, January of 2020, so right after the election. Okay. And at that time, certainly
That one had to have been 2021.
2021. I apologize, Your Honor. At that time, the Biden administration was making representations that they were moving forward to fix some of these problems with the NEPA, the rule that had been put in place by the Trump administration. And they put in their briefing and submitted to the court at that time that there would be a two-phase rulemaking. And the first phase of that would fix some very discrete problems. And that has been completed. And we are appreciative that those particular problems have been fixed. But this is a massive rulemaking.
The aspect of the courts getting involved in it at this point. I mean, you got an administration, you know, these things take time for the new registration. Otherwise, it'd be arbitrary and capricious. And so the two-phase process is going forward. It's not like they haven't done it. It's going forward, but maybe not at the speed you want it to go. Is that what you're saying?
Respectfully, Your Honor, I would respond to two things there. First of all, the Biden administration stated that the second phase of their rulemaking would be completed by the June of this year. That has not happened. We haven't seen any advance notice of rulemaking.
There's a lot of things that we thought would be happening by June of this year. That's the political side of these things. But my point being is it's going somewhere. I mean, we could hold on this case for. Who says you're going to get a decision from us anytime soon? You may be complaining. We figured that we get something by December. You might not get in something in next summer, and then by then you got something. But the point being is something is being done, has already been done. Some of what you brought in has been taken care of, and it's moving in that direction. I mean, at some point in time, there's a separation of powers issue to consider, and that is, yeah, we could, but you know, the administration, the executive branch is moving in a direction on this, and it just seemed reasonable. Other courts have done it too, right?
Well, respectfully, Your Honor, other courts have stepped in where plaintiffs are being harmed. And if I could say just make 2 points on this.
What you just said then, respectfully, other courts have done what?
Other courts have stepped in and have vacated rules from the Trump administration, regardless of the fact that there's a new.
It's held in abeyance pending.
Oh, you mean this particular? Yes. Well,
courts have done that.
Plaintiffs in those cases do not have the concrete injuries that our plaintiffs have. Perhaps, I don't know. I don't represent the plaintiffs in those cases, but if I could make 2 points. First of all, the Biden administration actually made clear in their phase 1 rulemaking that they do not intend to fully rescind all of the harms that was set in place by the Trump rulemaking. In fact, they said.
Yes, which ones they're going to do it, which ones they're not going to do it.
Well, we don't need to guess, Your Honor, because what we do know is that the law in place today is the law which is governing all rulemakings today and has been the law which has governed all rulemakings since September rules and NEPA processes since September of 2020. And we also know that our plaintiffs today are being harmed by that rulemaking. And then there's an additional point
Now,
that.
which rulemaking are you talking about? Are you talking about the original rule from 2020?
Yes, Your Honor.
You're not talking about the rules that each of these agencies are going to develop that implement that rule as they see it.
Well, if I could correct a misconception from the district court, Your Honor, the way that NEPA works and the way that the Supreme Court has been clear that NEPA works and CEQ agrees that NEPA works is these CEQ rules are the governing principle that govern all federal agencies today. They are binding law on all federal agencies, and that's from the Andrus case, and that is clearly stated in the regulations.
But here's something. Have they actually done any of that? Or you are in a position where it could happen because, as you say, it's binding. Has anything actually happened?
Yes, Your Honor. Just yesterday, for example, I was informed that plaintiffs in this case, who are the Calf Pasture River Association, are now facing a new timber harvesting project at Anchor Knob, which is in that vicinity in Virginia. And what they are finding is because the new rule is in place, the Forest Service is no longer conducting the same on the ground fact finding that it would have had to do prior to the rule being in place.
So why don't they challenge that, just like the Supreme Court said in Ohio forestry?
Well, Your Honor, this court has been very clear that we don't have to wait for the consummation of injury to occur.
Yeah, but in the example you gave, that certainly seems like an Ohio forestry case.
In that situation, the plaintiff's harm is not the environmental harm on the ground as it was in Ohio forestry. In Ohio forestry, which was brought under a substantive statute, the harm at issue was the harm to the forest. And what the court would have had to look at was whether the action was going to actually harm those people. The harm here is to the plaintiffs themselves, the plaintiffs' behavior, and what the plaintiffs are having to do in that case, and a whole host of other circumstances, like, for example, plaintiffs concerned about new poultry farms in Eastern North Carolina, which are harming their communities. What they're having to do is expand resources they previously didn't have to do fact finding for themselves, because the federal government is no longer required to do the fact finding and no longer required to give the notice that it has previously been required to do under the longstanding NEPA regulations. And we have declaration testimony in the record showing how our plaintiffs have already adjusted their behavior because this new rule is the law of the land today. And yes, we can hope that the Biden administration at some undetermined point in the future will fix it.
To really get to the heart of it in terms of the issue before us, the standing and rightness of this case. Aren't we to look at jurisdictional consideration from the time that you filed the lawsuit, as well as throughout that suit?
Yes, Your Honor.
Look at it from that light. How in the world is it foreseeable this forest plan issue was foreseeable?
Well, I was telling you about the forest plan because you asked about what has happened in the past year and a half.
Even if you tell me about it, it's, I'm getting to the standing issue in terms of where we are right now today. And some of the considerations that you bring, and when we look at what those things are at the time you filed the suit.
Absolutely, Your Honor.
In terms of where you go with that.
Right, and at the time we filed the suit, this was a rule which was issued by the Trump administration with big fanfare about how this was cutting NEPA regulations and eliminating red tape, and plaintiff groups at that time who had been using NEPA consistently for years as a tool to fulfill their organizational missions, both by getting notice, getting information, and submitting their comments, because as this court has recognized, NEPA is a democratic decision-making tool. At the time that rule was issued, it was extremely foreseeable that they would be impacted. And in fact, they immediately were impacted because they immediately had to shift their behavior to adjust for this new scheme which is still in place today, and which we have actually seen no concrete promise from the Biden administration that there will be a restoration to the previous scheme. And some of these changes were automatic.
Excuse me, I'm in sort of all of your, I'm sure, very erudite discussion. I'm losing track of the fact that the prior administration's rule that you objected to is gone. Right?
No, Your Honor.
It's been vacated. It's not being enforced. Okay, you tell me what the status is, and then we'll hear what the United States has to say.
Yes, Your Honor. The rule is in place today, and if you look up.
But is it being enforced?
Yes, Your Honor, it is the law, and I can quote to you from section 1506.13 states, the regulations in this subchapter apply to any NEPA process begun after September 14th, 2020. And that is the law today. This rule is binding on all federal agencies.
For the district court's conclusion that wasn't right. Maybe we can get to it.
Yes.
Telling me only the facts and argument on your side and not addressing what at least the other side says.
Absolutely.
Doesn't advance your case.
No, I'd be happy to, Your Honor. And unfortunately, there was a misrepresentation made by counsel who is no longer counsel in the district court that these rules could not go into effect until other agencies made their own implementing regulations. And that fact is not correct, and that is belied by the plain text of the regulation.
And is that in the district court's opinion?
Yes, it is.
That is the basis for its holding? Is that what you're telling me?
That is in part the basis of its holding, yes, Your Honor. Well, Your Honor, the district court based a lot of its opinion on Ohio forestry, which I was just discussing with Judge Agee, is a very different factual circumstance and legal circumstance to the one we have here. And largely that's because NEPA is a procedural statute that guarantees procedural rights. And so the plaintiff's harms are the loss of that procedural right. They're not the loss of the harms on the ground. The rightness question is also really different than Ohio forestry, because in Ohio forestry, what the court had to do was.
So you're claiming that your injury now is a informational injury?
Your Honor, the plaintiffs do have informational injuries as well as the loss of procedural rights that they are guaranteed.
Those haven't gotten a very good reception courts.
Well, Your Honor, this court
they'll make the point that, you know, if you can claim an informational injury every time the government agency either doesn't do enough or weighs things differently in terms of the information they're going to give out, everybody has standing.
That's exactly correct, Your Honor. And that's why what the courts have said is that informational injury needs to be tied to a concrete injury that is particularized to the group in question. And that is precisely what has been demonstrated in the declarations here. These are not groups just saying generally, we wish we had more information. These are groups saying we have a long-standing practice of using the NEPA process to get information, for example, about new poultry farms in our neighborhood. They have declared in sworn testimony that has not been disputed that this is the tool they have used, and they have subsequently lost that tool. It was like a radar out there, which they could know, okay, we know that this poultry farm is coming up. We can tell our clients about it. We can submit comments, and that radar for them has gone dark.
That without this, there's no way they're going to know there's a new poultry farm going in.
Yes, Your Honor. These are very small groups. For example, Kent Burdett, who's a plaintiff in this case, he runs the Riverkeeper, Cape Fear Riverkeeper, and it's really just him and some volunteers. And the rest of the time, he's literally kayaking up and down the river, looking for harms in the river. He's doing volunteer cleanups. He's doing fundraising. And what he has declared in his testimony is without this tool, which he has relied on, and he's certainly by many means not the only one, without this tool, he has to shift his attention to doing that fact finding. And that takes him away for things like the river cleanups or the fundraising. And that is a recognized injury by this court and by the United States Supreme Court when you have to adjust your behavior.
The declaration indicated that this was not going to be forced against that controlled animal feeding operation. What does that mean?
Well, NEPA is not really about enforcement, Your Honor. NEPA is about the guarantee of procedural protections to the natural environment, and that no federal project can proceed without them.
Enforce it, then what's the end?
Well, we don't know whether or not that one particular agency official cannot just vacate a case by saying they voluntarily will choose to violate their own law.
So what are you gonna do? How are you gonna make them do it? They say, we're not gonna do it. Now you want the sue to say, don't do it. And so then I'm trying to understand it. What does it mean when you got an administration that's moving directly, and yeah, it's not gotten rid of the whole matter, but there are at least 2 or 3 things that you filed in your complaint that are clearly now moved as a result of phase 1. That's yes, right?
Absolutely.
And then you got this exemption with this CAFO that's there. And I mean, there's movement, and we also know you can't just change a regulation overnight. Mike would like to, when you come in as a new president, you've got to go through a whole process. Otherwise, it's arbitrary and capricious, and it's moving in that direction. And at least something seems to be happening, and you're shaking your head. But at the same time, I guess the question has been here, how much is being enforced? But when it says it's not enforced, at least as the CFO, I was asking, what does that mean? And I don't know. This is new stuff to me. When you said portrait, sound back to me as animal somewhere in there. When you're dealing with a controlled animal feeding operation. So what's that effect? And your point being is the fact you don't enforce it mean it's still there. Is that it?
I think the fact that our plaintiffs no longer have a law in place which says that these types of poultry farms are subject to NEPA, and that they will get that notice and that opportunity to participate in the process is the injury to them, because they have had to shift resources to do that work themselves. And I'll reserve the rest of my time.
All right, thank you very much. Mr. Barbender, we'll hear from you.
Yes, thank you. May it please the court. My name is Alan Braybender, and I represent the Council on Environmental Quality. Although this facial challenge was inappropriate from the start, subsequent events now show just how wrong plaintiffs' speculation turned out to be. For instance, when they filed their complaint in July 2020, they couldn't predict the results of the 2020 election. Now, CEQ under the Biden administration is committed to revising the 2020 rule in such a way as to avoid the kinds of harms that plaintiffs speculate could occur if some federal
find that. I tried to tease that out of your colleague, but he wasn't going there. You say that Biden administration has said that it's going to.
It is committed to revising.
It's committed. Okay, so where do I find that in the record?
We provide citations to the notice and the rulemakings in our briefs, Your Honor.
I thought that her response was that somebody misstated that in the district court counsel that is no longer representing you all.
Sure, I think that pertains to a different issue, but let me speak to that.
Okay.
The former AAG said something along the lines of the 2020 rule is a rule about rules that has no immediate effect.
That has what?
No immediate effect. That actually is a true statement. Now, I think the district court mistook that to mean that the 2020 rule couldn't take effect.
I see.
Until these other federal agencies promulgated their own internal regulations. That's not true. The 2020 rule is in effect. But Judge Jones was still correct that this case is not ripe because it is not fit for review under the National Wildlife Federation case, and because the relative hardships weigh in favor of finding this case not to be ripe under Ohio forestry.
But your opposing counsel says that even in those situations where they're not awaiting further rulemaking on a particular project, that their injury, as I understand the argument, is that because we're not getting the information that we received before, our groups are having to act differently now, and that injures us from a constitutional perspective.
So plaintiffs are speculating that they won't receive information. There has been no denial of information as of yet. And so they're taking actions based on this speculation of non-imminent, non-concrete harms, which the Supreme Court in Clapper said is insufficient.
Excuse me, are you providing the information that was provided before the Trump rule?
Well, that depends on how any agency may interpret and apply the rule, because the rule is not self-implementing. It can only have effects to the extent some other federal agency applies it during its own project decisions.
Well, I thought your representation just 30 seconds ago was that they're saying they didn't get the information, but they do. But now you're telling me it depends on other agencies. So,
well, I'm saying
they're getting the information.
I'm sorry, go ahead, Your Honor.
Are they getting the information or not?
It depends on how another federal agency, they're speculating that they're not going to get the information because another federal agency is not going to give it to them. For instance, much of their claims of harms are based on the notion that the 2020 rule deleted the definitions of indirect and cumulative. And therefore, they're not going to get the types of information on impacts that were previously classified as cumulative, such as climate change impacts, for instance. But what we're saying is they have no idea whether or not some agency is going to analyze climate change in their decisions or not. They're speculating that they won't because of the 2020 rule, but that's just pure speculation. And that's the kind of information they say that they're not getting, but they have no basis.
Well, I understood opposing counsel to give us an example of something that apparently happened just in the last few days. Now, whether or not we can take that into account a year, 2 years after filing of the suit's a different question, but they're saying that there was some forestry project and NEPA directly affected the information they would receive, I presume, without a further regulation from the U.S. Forestry Service or whatever agency handles that.
Sure, and I'm not familiar with the project they're discussing, but I would doubt that's the case. Because CEQ has extended the deadline for agencies to promulgate their own internal regulations implementing the 2020 rule, agencies have responded by continuing to apply their internal regulations implementing the 1978 rule. And so I'm unaware of any project on the ground.
So they're implementing now the same regulations that existed before the 2020 rule.
They continue to apply their internal regulations because they haven't promulgated new regulations under the 2020 rule yet. And so because of that, I'm unaware of any project. And of course, there are NEPA challenges out there, but I'm unaware of any NEPA challenge where the argument is that the harm is caused by the 2020 rule as distinguishable from the 1978 rule. We're aware of no case where the argument is the 2020 rule itself caused the harm. And the large part of why plaintiffs' declarations are filled with speculation is that they filed 2 months before the rule even took effect. And even 2 months later, when the rule was scheduled to go into effect, in order for the rule to...
We're talking about the Trump rule, right?
Yes.
Okay.
And so even 2 months later, for the rule to have effect, some other federal agency is going to have to apply its rule to its own decision. But that NEPA process takes months and sometimes years, such that when the plaintiffs filed their suit in July 2020, any concrete application of the 2020 rule was way off in the distant future. And because of this, the declarations that plaintiffs submitted with their complaint are necessarily and fatally based on pure speculation about what some federal agency might do in the future that might cause them some harm. And that's just a sort of speculation and guesswork, which does not amount to Article 3 case or controversy.
What is the status of the 2020 rule now?
Well, It is still in place, although it has been revised by CEQ's phase one rulemaking, which did some important things. It reinstalled the definitions of indirect and cumulative, and it made clear that the 2020 rule is the floor and not the ceiling for environmentally protective NEPA procedures. Now, the adoption of phase one means that the predicted harms that plaintiffs speculate could occur now will not occur, because many of the harms were based on speculation that some federal agency might not analyze an impact that was previously classified as indirect or cumulative. And they speculated from there that this could cause environmental consequences, it could deprive them of information, and they would therefore have to divert resources to get this information. But of course, now the phase one rule restores those definitions, so these harms will not occur. Other harms are based on whether or not an agency may decline to consider their comments or may forego NEPA altogether. But these harms, in addition to being speculative, are based on the notion that the 2020 rule created a ceiling. They would claim, for instance, that the federal agencies have no choice but to apply what they call the heightened public participation requirements, or they have to exempt projects from NEPA.
So are you aware of any agency that would be controlled by NEPA that has actually promulgated regulations under the 2020 rule?
I do not believe any agency as of yet has promulgated comprehensive regulations implementing the 2020 rule, because it would be a waste of time. They know that the Biden administration is hard at work revising the 2020 rule, such that it wouldn't be prudent to waste resources.
How do we know that?
Based on what I'm telling you, Your Honor, I don't know if there's anything that you can look at. If you want,
since June of 2022. They had those 48 meetings according to that Southern District, New York case up there with the CEQ, and had all those meetings and
right.
nothing.
Right. The fact that there is in fact no regulation out there shows that they're not working on very fast.
What? I didn't hear that.
In fact, there is no comprehensive regulation implementing the 2020 rule. Shows at least agencies are not making it a priority.
They're what?
They're not making it a priority to adopt new regulations implementing the 2020 rule.
Well, what are we to make of that? These plaintiffs are here in court with their claims, and you're saying, well, we're going to make a rule that makes this all ridiculous, but we're taking our time.
No, what I'm saying is, I'm not saying that, Your Honor. I was responding to the questions about the status.
I used the information that you gave my colleague to make your response. You're right. You didn't say that. So what is your response to the fact that there hasn't been any action?
Well, I mean, CEQ is a small agency. It is hard at work on a comprehensive revision. It has had dozens and dozens of meetings with interested stakeholders. It's going to take some time. Yes, it's true that they originally targeted June 2020, June 2022. And that's unfortunately been prolonged, but CEQ is hard at work on a rule.
It sounds like it's very possible that there'll be another election, and then this rule will be back in effect, right? The way it exists right now.
It's possible. That's true. And with respect to any rulemaking, at the change of.
But not any rulemaking is in front of us.
True.
This one is.
True. But of course, jurisdiction is assessed at the time the complaint was filed. And at the time the complaint was filed, plaintiffs just don't have the facts to show that there was a ripe controversy or that they had standing. And let me address this claim regarding the concentrated animal feeding operations. Yesterday in their 28J letter, they claim that these exemptions for the CAFOs, as they're called, is automatic, which is not the case. There's no provision of the 2020 rule that's automatic. Some federal agency, some federal decision maker has to make a decision to apply it. And as a fact of the matter, the Farm Service Agency has not been using this exemption. And the fact that the phase one rule now makes the 2020 rule the floor, not the ceiling for environmentally protective procedures means going forward, the FSA could continue to do EAs or EISs or whatever they would like to do on these loan guarantees. I'd also note that plaintiffs' claims here are speculative. As Judge Jones said, this is out of all of the speculation, this is some of the more attenuated speculation, because plaintiffs don't cite an example of a single operation in a geographic area in which they have interest. There's no proposal that they cite. So what they are saying is that there seems to be some statistical probability or reasonable likelihood that some private organization may try to locate an operation in a geographic area where they have interest. But post Summers and post Clapper, that kind of reliance on statistical probability or likelihoods is not enough to justify Article 3 jurisdiction. From there, there's more speculation. So they speculate a private entity may locate an operation in a geographic area. They speculate that they will apply for a federal loan guarantee. They speculate that the FSA will grant that guarantee. And they speculate that it will do so without doing NEPA. And then they further speculate that the reason they didn't do NEPA was the 2020 rule as opposed to some pre-existing exemption that would be available to it. So this is speculation upon speculation upon speculation. And even sort of one chain of speculation isn't sufficient, but this sort of multiple chains of speculation is what Judge Jones said. This is one of the more attenuated claims.
So you've cited Judge Jones' opinion a couple of times. Is there anything that, in your view, is erroneous in Judge Jones's opinion?
Oh, yeah, I spoke to it earlier. Judge Jones seems to be of the impression that the 2020 rule couldn't take effect until these agencies implemented their own internal regulations. That's not the case. But other than that, I think Judge Jones was absolutely correct.
So, I'm so sorry. And your response to that is the rule takes effect, but the agencies have to do something under it to have any.
Right, the rule is a procedural rule. There's a lot of discretion.
I see. So it doesn't affect anybody, in fact, until the individual agencies act. Is that correct?
That's absolutely correct, Your Honor.
Okay, sorry, Judge.
I think that's
okay.
Your argument here is the rule, the 2020 rule has taken effect, but it doesn't affect anybody until these other agencies do whatever they're going to do.
That's correct, Your Honor.
All right.
And we would ask for the judgment to be affirmed. Thank you.
All right, thank you, sir. And now we'll hear from Mr. Kimberly.
Thank you, Judge Agee. If I may, I'll start. I'd like, if I can, in the short time that I've got, briefly to address the question of an abeyance and then touch on the merits and offer what I think is a middle ground between the parties here. So first, as to an abeyance, Judge Wynn, I think what would make an abeyance not warranted in this case, at least in its current posture, is that the district court's decision was one based on standing. It was not about the merits of the rule itself. And as Judge Motz noted, the likelihood that there's going to be further rulemaking in this area is high. And at this point now, the parties have spent more than a year litigating just the question whether the court has the authority to decide these sorts of challenges. The case is fully briefed and presented to this court just on the question of standing. And I think having the court's guidance for litigants moving forward on what sort of standing principles ought to guide challenges to CEQ NEPA regulations.
How could we get into those complicated standing issues if the rules are going to just change again anyway?
Well, I think the answer is, first and foremost, there has been one change, but we don't even have, so that in the two-phase approach to changing the rules, the phase one is done and complete, but that leaves plenty of live controversy here. The phase two rulemaking hasn't even commenced. There isn't even a notice of proposed rulemaking. And as my friend on the other side observed, there's no telling when that's actually going to come. So as of right now, I mean, it's likely to be years before we see a final phase two rule, if ever we do, before the possibility that changes.
But while they're waiting on that, they're being injured in the interim.
Well, that's right. And that's why I think it's important for this court to reach the standing question. Now, of course, our position on that front is that this court should affirm what we take to be a very well-reasoned decision by the district court below, providing helpful advice and guidance to other litigants who might, including my clients, who might find themselves challenging CEQ regulations moving forward. That is a live issue, and it's one that I think it would be helpful to have a decision on.
Succinctly tell us from your client's perspective why the injury component of the appellant's argument is incorrect.
Right. So and on this court, Judge Agee, we would ask the court to apply the same standard for standing that we would hold ourselves to with tables turned. And it's just to say that Article 3 requires allegations that are concrete, actual, and imminent, and they can't rest on speculation. So that doesn't describe the harms that the plaintiffs have presented here, because they haven't identified, first, a specific federal action, two, that is subject or imminently will be subject to a NEPA review, that will be conducted pursuant to the elements of the 2020 rule that they challenge. And I'll come back to that in a moment, because I think that's an important point, Judge Motz, of some of the questions you were asking. Four, that result in some identifiable difference in both this, in either the scope or manner of the way that the NEPA review is conducted, that in turn is substantially likely to cause the plaintiff's members a concrete harm. And that might be the diversion of resources, it might be the frustration of institutional mission, it might be some environmental impact. At each one of those 5 steps, the plaintiff's standing declarations fail. And I would point the court to the Burdett Declaration, which is the #1 declaration cited in the reply. It was what was just cited in my friend's presentation. They are at paragraph 13 of the Burdett Declaration. This is JA 637. The statement is, I am concerned that if the final rule is not vacated, citizen input on project design will no longer be possible. No indication of an actual federal action to which NEPA review would be required, the ways in which citizen input would be inhibited, the ways in which that might influence the course of the NEPA review resulting in injury. I would say also, Judge Agee, to your point about informational injury, the injury, this court's cases teach that kind of injury is really only applicable when there is an affirmative legal right to receive information, and that information is being deprived. But as the DC Circuit held in a case that we cite in our brief, this is the Foundation on Economic Trends case. I'll just cite briefly from that case. An organization's desire to supply environmental information to its members and the consequent injury it suffers when the information is not forthcoming in a NEPA review without more is not enough in first standing, because it would apply really to anybody. That is a generalized term.
You're standing to intervene in this matter.
Well, the intervening, I suppose it's first an open question whether defendant interveners have to establish Article 3 standing, which is typically a standard.
What would give you standing to be in this case?
So our standing, if it were something that we had to prove in this case, would follow from the same basic standards that I just described. We have members who have identifiable projects that are under NEPA review.
You're being regulated.
That's exactly right. We participate in the NEPA review.
You've got some regulations that are directed to you. So you think that's enough to overcome the speculative aspect, just like the other side?
That's right. Our members' participation in NEPA reviews, when they're the ones, for instance, seeking permits, is mandatory.
You get regulations just directed to you as the other side. That's good enough.
Well, actually, just to clarify a point that Counsel for CEQ just made, these are really regulations of agencies. The way that the agencies implement these NEPA regulations is by conducting NEPA reviews. So we still have to have a NEPA review as to which these rules apply. If it were, for instance, a challenge to the phase 1 rule, we'd have to show, for instance, that a member had a pending NEPA review, that the phase 1 rule would apply, and that it would inflict costs as a consequence on our members, for instance, further delay in the completion of the NEPA review or more burdensome analyses in the NEPA review. And our point is simply that the same standard should apply to the plaintiffs. And
Yeah, but you say they don't have standing. I think that's the gist of my colleagues. If they don't have standing.
Trying to understand how if a parallel case came up and you had to challenge these rules in the specific in first instance, I'm just thinking about you and how you get here.
Well,
I understand you think an intervener, you don't need Article 3 standing, you just intervene, kind of get into it. But I'm just thinking, you're standing here before us arguing.
right.
We have some basis for doing so.
And with the table turn, as I say, we would have to prove what I've just shown. Judge Motz, to your point, our disagreement with the plaintiffs is simply that what they have put forward, the 52 declarations that they've put forward, fail at each step that I've suggested would be necessary. They don't actually identify any particular federal action to which NEPA review would apply under these rules.
I think I understand what you're arguing. What we're asking you is what is your role here? And you're just saying no, but because we're an intervener, we don't have to show standing. Is that what you're saying?
Well, I think yes, our first point is that it's
pretty comparable to their standing.
Sorry?
I would say that your standing, if you had to prove standing, is pretty comparable to the plaintiffs.
Well, I think the point is that a defendant doesn't have to prove Article 3 standing, but I
suppose interest in the case.
Yes, our interest in the case.
Yes, it's the same basis they got. You think you being regulated, and that's speculative from their perspective, but from yours, you think it's something that gives you enough to be able to intervene in a case and argue just like you're the party here in front of us.
Well, respectfully, Your Honor, we are a party. We're an intervener.
That's what I'm
but there are very important distinctions.
You gave a different categorization. I'm gonna have to really study that one now, the intervener, to see if you can just boss in anybody without any standing, you just intervene. There has to be something. We have a basis there. And I think that's not
right, Your Honor.
the case. It was just an interesting point. You don't have to go into it from my perspective, but it was just interesting when I was sitting here thinking about who are you. I says, you're in the same position as they are. You know, you're being regulated. And you feel like, well, that's it. That affects me. So, and yet you say they don't have standing. They don't have enough to be here.
No, so Your Honor, the distinction is, I think you've just got to have a concrete injury. And it's so what all they put forward is sort of general speculation about concern for informational.
Well, if you brought a parallel case, you'd have to have a specific.
We would have to have a specific injury. We'd have to show.
Don't have any such thing now.
Well, we haven't submitted declarations to the court because, again, that wasn't part of it.
We don't have anything, you know, you're in the same position.
But Your Honor, again, if I may complete the
Seems
thought.
like your point would be, well, yeah, maybe I don't have any kind of standing here, but that just proves they don't either.
Well, I suppose that would be the case, although again, the distinction is so if they could come forward and show, for instance, that they had a member that was participating in a particular NEPA review, that they were demonstrably being denied information that was available to them before under the old rules that is now not available to them under the new rules. And in the course of that actual rulemaking, that actual NEPA review, they therefore had to incur expenses, real expenses, say filing and litigating FOIA litigation, they would have standing.
Sorry.
You're good.
Well, I was just going to ask, sorry, it was still early. Okay, yes, I'm fine.
All right. Thank you very much.
Thank you.
All right. Ms. Hunter, you have rebuttal time.
Thank you, Your Honors.
Excuse me, before you start, my colleague, Judge Agee, said at one point, the 2020 rule is in effect, but doesn't have any affect. Isn't that correct?
It's not, Your Honor, and my opposing counsel
sounded like it pretty much.
It is in effect, and it is as the Supreme Court said in Andrus, CEQ regulations are binding on all federal agencies, and I believe CEQ's counsel admitted today that agencies do not have to put their own implementing regulations in place for the rule to take into effect.
Council, if you want to remove your mask,
Oh,
that
thank
might
you.
help a little bit.
And, we noted this in our reply brief, for example, on page 3, we point to a Forest Service EIS where it says, quote, all projects with notices of intent initiated after September 14th, 2020 will use the new regulations. That is just the law. This is the law on the books. And despite what my opposing counsel said, this is not a fully discretionary rule.
Which regulations is it that they're going to use? Because I thought I understood opposing counsel to say that he thought there weren't any new regulations implementing the 2020 rule out there. So what specifically are you saying is a regulation that injures you now?
Yes. So they will use the CEQ regulations as agencies generally do, and as cases which have come before this court. For example, the Department of Transportation relies on those CEQ regulations, and what those regulations do, and there are hundreds of changes in these regulations. For example, they change when the agency has to use up-to-date scientific information. They change the standard for when plaintiff groups can get into court and really raise the bar of what they have to do for exhaustion. So that is a harm that happens now to plaintiffs today because they have to meet that exhaustion standard or risk losing something.
Can you point to somebody that has been harmed by any of this? I know you say in the sphere, your clients are all being harmed, but that is actually partaken in this procedure?
Well, where we are at this point, Your Honor, is plaintiffs who don't know whether NEPA is being used or not because they have previously relied on the NEPA process to alert them to when NEPA reviews will take place. But because this regulation specifically exempted with no discretion certain types of categories of environmental reviews from needing any NEPA review, those plaintiffs are harmed. I can point to specific groups like Cow Pasture River Association, like Mountain True, who rely on Forest Service regulations, which have been changed in accordance with the 2020 regulations to exempt larger stands of trees from the NEPA process. And there are specific examples which are moving ahead today under those categorical exclusions, which were promulgated under this new regulation. Another example would be the Mountain Valley Pipeline, which needs additional NEPA review from the Bureau of Land Management. And today, the law on the books, as I stated, is that the 2020 rule is what applies today.
Okay, now I know you want to tell us everything, but it actually is important for you to listen to what we are concerned about. And so what would you have us do about that, all of those things? What is it you want us to do? You want us to reverse the district court and do anything else?
And remand to the district court to hear our motions on summary judgment, Your Honor. The CEQ is no longer defending the rule on the merits, and we would like the rule to be vacated. And just to answer Judge Wynn's concerns from before about why this is important, there has already been an attempt by Congress to vacate phase 1 of these regulations. If there is another election, as you recognize, Judge Motz, we could be in a very different situation. And it's really important to restore.
Why does that help you?
Because right now, the law of the land is the 2020 regulation, and there needs to be some legal clarification on the question of whether that 2020 rule was promulgated according to law, according to the requirements of the APA. That is the question that these plaintiffs want answered. And we want to be sure that if that rule was illegally promulgated, it is stricken from the books, and the 1978 regulations again become the baseline from which CEQ can work from.
So why can't you make those challenges in the first instance? So in your example of project, why wouldn't you challenge it then when you've got a very specific, concrete harm as you see it, that they're cutting trees that before they wouldn't have cut, and that creates an injury that's cognizable. Why wouldn't you do it then?
So I think there's two reasons, Your Honor. First of all, that would be a challenge to the Forest Service, but the bad actor here is CEQ. It's CEQ's rulemaking, which is the problem here, that it wasn't.
You could challenge both of those at that time.
And the second reason is that plaintiffs, and this court has recognized this in Gaston Copper and other cases, plaintiffs in environmental cases do not have to wait until trees are being cut down in order to have an injury. The redressability and imminence requirements for environmental standing are significantly lowered for that reason. And at the time the plaintiffs brought this case, their harm was imminent. And we have seen that harm play out as these plaintiff groups no longer have that procedural tool and that notice that they had in the past to use. And they've had to shift their missions accordingly. And they may result now in not being able to get into court to challenge projects harmful to them because of the changes in this rule. And that's a real harm to community groups who can ill afford experts to do that comment writing for them.
All right. Anything else you want to tell us in about 30 seconds?
I think the key points is that this is not a speculative rule. Yes, we are grateful for these changes to indirect and cumulative impacts and alternatives, but there are a number of other really key provisions that were changed in the 2020 rule, which are in place today, which mandate that agencies have to do less than they previously did. And to suggest that agencies are just going to voluntarily go above and beyond what the baseline is, the significantly lowered baseline, is a type of speculation that courts have found strains credulity. And with that, I would ask that you vacate the district court's opinion and return this for a full hearing on summary judgment on the legality of that rulemaking. Thank you.
All right. Thank you very much. We appreciate the arguments from all counsel. And we regret we're not able at this time to come down and greet you as we normally do, and hope you'll return on another occasion when we can do that. So with that, I'll ask the clerk to adjourn court until our next session.
This honorable court stands adjourned. God save the United States and this honorable court.